guess we can. Let's,
I think so. Time is.
yeah. Okay. Welcome back, everyone. If we could take our seats and get started with our final session for today. So before we begin, I wanted to echo my previous colleagues' expression of gratitude to Georgie and JJ and the UN Environment Program, as well as the REL team, Matthew and Colleen and Rocky and Pum for organizing this great event. And then finally to all of you participants who have graciously joined us to give us your attention and your participation and hopefully your insights when we get into the discussion later after the presentations. It's a pleasure to be here with you today. My name is BJ Schulte. I'm an environmental lawyer from the United States, but currently I'm working as the Mekong Region Policy and Legal Advisor with Earth Rights International, based in Chiang Mai, Thailand. And this is personally a very exciting panel for me. We will be discussing public interest environmental law and the intersection of climate justice and public interest environmental law. The discussion we'll be having today will focus on innovative legal strategies and innovative regulatory and policy frameworks to address the climate crisis. I don't think I actually need to say anything to this crowd to emphasize the urgency of the climate crisis, other than to reiterate some of the information we heard from Babu on the first day, where he was providing us some information on the climate crisis, and notably the IPCC's sixth assessment report, which came out earlier this year, which demonstrated yet again that the time to act is now. We don't have much time left, and we need innovative strategies, and we need to act with urgency if we want to solve the climate crisis. So today we have four very distinguished panelists, and we'll be exploring, like I said, innovative legal strategies and examining both existing legal frameworks and hopefully discussing ideas for ways to transform those legal frameworks to address the climate crisis. So before I begin with the introductions, I will remind everyone that there was a mistake previously in the agenda that said we would end at 4:30 today, but we're going to keep you till 5 o'clock. I hope that's okay with everyone. And hopefully that will leave us some more time for some very interesting and enlightening discussions. So without further ado, I'd like to introduce the panelists. To my left is Reynaldo Sembiring. Did I say that right? Okay. Also known as Dodo. Reynaldo is the Executive Director of the Indonesian Center for Environmental Law and also Chairman of the Friends of the Earth Indonesia. Reynaldo is teaching environmental law at the Indonesian Supreme Court Judicial Training, as well as several law schools in Indonesia. He is a sworn attorney and an active public interest environmental lawyer, and has been leading advocacy on issues focusing on developing Indonesia's anti-SLAPP mechanisms, climate change litigation, climate change advocacy for forest and other land uses, and just energy transitions. And we'll be hearing from Reynaldo about some of the current trends with regards to climate litigation in Indonesia. To Reynaldo's left is Shu Ting. Shu Ting is a law and policy advisor with Client Earth, based in Beijing, China. Prior to joining Client Earth, Shu Ting was a program manager at the Heinrich Böll Stiftung office in Beijing. She focused on ecology-related issues such as climate change, energy transition, environmental rule of law. And before that, she had worked for a research institute affiliated with the Chinese Academy of International Trade and Economic Cooperation, which sits under the Ministry of Commerce in China. Shuting will be sharing with us some of the current ongoing efforts to develop multi-stakeholder climate governance in China, involving the robust participation of NGOs in China. Next, to Shuting's left is Shella Chowdhury. Shella is a JD candidate at Yale Law School in the United States. Her research and studies focus on the intersection of human rights, climate change, and international law. Currently, Shella is working at the Asian Environmental Compliance and Enforcement Network, where she supports research on the use of public litigation as a pathway to climate justice in Southeast Asia. We'll be hearing from Shella about some of the trends with regards to climate litigation in the Asia-Pacific region. And then last but not least, we have Renee on the end. Renee is a legal officer with the UN Environment Programme's Law Division based in Nairobi. She has brings 14 years experience as an environmental lawyer working at both national and international levels. At UNEP, her portfolio includes leading the division's work on thematic areas of air quality, climate change, management of ozone-depleting substances. And prior to joining UNEP, Renee worked with the Intergovernmental Hydrological Program of UNESCO on promoting cooperation in shared water basins. And Renee will be sharing with us summary of the UNEP's very informative, and I would encourage you to check out report on global trends with regards to climate litigation. So without further ado, I will hand it over to Reynaldo for our first presentation.
It's okay. Okay. Yeah. Good afternoon, everybody. I think it's a great time. I can meet all of you and sharing about the Indonesians, some of the Indonesian prospect and lesson learned from the climate litigations. Actually, yes, this is the critical time because usually in my country, after the long sessions in the afternoon, some of people will feel sleepy because so tired. But we hope that we can discuss and learn many things from the Indonesian's progress. Okay, I would like to explain the some of the progress of the climate litigation in Indonesia, but it will be very Indonesian context. And I start with the what are the drivers of the climate change litigation in Indonesia. Actually, climate change litigation in Indonesia are driven by specifically inadequate actions to tackle climate change and generally by unsustainable business practice and or environmental degradations. And usually, plaintiffs are seeking relief through the enforcement of existing environmental or climate laws that might compel the government or business actor to comply and contribute less to climate change. Is like omissions by the governments. For example, if the government doesn't have the ambitious target in the climate agenda. The second one, integration of the climate action into existing environmental law, energy, natural resources, and other sectors to the law and the documents or any planning or policy. The third one, establishment of the clear definitions of human rights and obligation affected by climate change, because usually we are still struggling how to connect about the climate change to the human rights principles. It's something that we still develop in Indonesia. It's not only for Indonesian CSO, but also for Indonesian scholars and lawyers. The last one is the compensation for the climate harms or contribution to climate change that might manifest into negative impacts. How we are, particularly for the I cells to classify some of the environmental litigations or the public litigation as the climate change litigations. We usually use the chart or the standard from the Pil and Osowski. So you can see the chart. But after many of case, Indonesia actually have more than 20 climate litigations. However, just one, the climate litigations, put the climate change as the central issues. Most of the litigations put the climate change as the peripheral issues, and the rest of them is just the motivations. So climate change is not central. Climate change just argue as the impact by some of the environmental degradations by the omission of the government or by action company. Okay, I have mentioned before that there has been growing cases of climate litigation in Indonesia with more than 20 cases in total, and just one in the central issues. Most of them is the peripheral issues. And majority of the case raise environmental issues as their core, where the climate change is a follow-up impact of the environmental damage occurred or experienced by the plaintiff. In recent year, I think this the good things because plaintiffs have developed knowledge and awareness on the climate change issue and litigation strategies. This reflected from recent cases that have started to specifically raise the issue of the climate change as their core argument. For the example, youth public inquiries, some of the young people submit the petition to the Indonesian Human Rights Commissions on the climate change impact. So they argue many things about the climate change issue and what the impact for the people, for the fisheries, for the farmers, and for the young people. And the other one is Tanjung Jati coal-fired power plant case. Actually, this is one of the case that against the coal-fired power plant, but the plaintiff put the climate argument as the central issues. You can see the progress of the climate litigation cases in Indonesia since 2009 until this year. And the contributors for the climate litigation in Indonesia, or the sectors, I mean that, is come from the two sectors. The first sector is the FOLU, forest and other land use sectors, because Indonesia, many of the forest fires cases and illegal logging cases. So usually plaintiff will explain and argue about the carbon release by the forest fire. And the second one from the energy sectors is about particularly from the coal-fired power plant. So the plaintiff will explain about how is the emission from the coal-fired power plant can giving the negative impact for the climate. Okay, this is the some of the overview climate case in Indonesia. I start with the plaintiff. If you look the chart, the plaintiff, more than 60% of the plaintiff is the governments. Why? Because in Indonesians Environmental Protection and Management Act, government has the authority to file the lawsuits against the company which make the environmental damage or environmental pollutions, and the government can request the company to pay compensation or to restore the environment. That's the government standing under the Ministry of Environment and the Forestry. The another plaintiff is environmental organizations. Yes, but it's very limited because the environmental organization in Indonesia doesn't ask about the money, so they just can request about do something or some the action by the government or the company to restore the environment. And the other one is the citizen lawsuit or the public individual. Most environmental organizations or citizens through citizen lawsuit file the lawsuits on the basis of protection of fundamental rights. Rise to life, rise to health, and rise to healthy environment and protection of their living space and the interest of the environmental itself. So it's different, the government standing and the public litigations. In the government, they request usually the compensation for the environmental restoration, but for the citizen or for the NGO, they ask the government to make the better policy to protect their fundamental rights. So I think this is unique and very interesting to like the make each other complete. And the claims, because because many of the plaintiff is the government, so they ask about the damage. The claim is about the damages, and another claim is about the omission or neglect of the duty. Usually it's the litigations by the citizens. The other one is the permit, because in Indonesia, most of the environmental organizations believe that if they can cancel the permit through the courts, so it can cancel the business actor and business activities, sorry, and that it can stop or halt the emissions like that. Okay. And what is the interesting issues or things from the Indonesia? You can see that I bold that judges have to use this principle to integrate existing environmental principles like the precautionary principles, sustainable principles into the government's act or decision making. So in Indonesia, sometimes judges are more progressive than the governments. So sometimes judges can follow and agree with some of the argument by the citizens or by the NGOs. Lastly, the unlawful clause used in citizen lawsuit case also include the violation of right as one of the element on unlawful act. However, until now, there has not been a single environmental case declaring human rights violation as an unlawful act and tends to separate as the two different systems. I think it has mentioned, it mentioned by my colleague Bella at the Jakarta air pollution case before, because for the judge in Indonesia, they're confused. Sometimes they can feel confused about the gross violation of human rights and violation of the human rights. They think that the violation of the human rights automatically is a part of the gross violation of the human rights. So it happened in the Jakarta air pollution case. So until this now, there is no just consideration about the human rights in Indonesia. So it's one of the work home from the Indonesian lawyer how to bring the climate litigation with the solid the human rights principle argument. I move to the one of the interesting case in Indonesia that I mentioned. This case is the climate litigation as the central issue, as the first category, Tanjung Jati A coal-fired power plant case. In the case summary, so you can read the case summary. The plaintiff is the Walhi Friends of the Earth Indonesia. Filed a lawsuit against the West Java governance, West Java province governance, because they issue the environmental permit for the Tanjung Jati A coal-fired power plant case. So the plaintiff have the argument if because the government issued the environmental permit, it can make the release of is about the 20 million gigaton CO2. It will be released to the atmosphere. So that's the basic argument by the plaintiff. And plaintiff also put the argument about the intergenerational equity. And plaintiff also stated that the West Java government doesn't have the doesn't do the precautionary principles because in the EIA, Environmental Impact Assessment, there is no assessment about the climate risk. There is no assessment about the climate impact. So what is the lesson learned? The first is proving the amount of emissions contributions is important to determine whether the issuance of the CFPP permit can be considered unlawful. And furthermore, the sum of the emissions contributions can be used to build a causality between certain contribution to rising greenhouse gas emission concentration temperature that trigger the climate impact. And the other lesson learned is the judges decided that the state is obligated to prevent the impact of climate change in order to fulfill the realization of a healthy environment and guarantee the quality of life for current and the future generation. But just, the judges is still not talking or have the strong consideration about the human rights. Just stated that it's important to consider about the how to make the implementation the healthy environment principles like that. And what is the impact of the future strategy? The first is the potential wave of the cases that challenge CFPP or the fossil fuel power plants permit on the climate grounds. So it giving some inspiration for the next cases or for the some of the environmental organizations. So it possible to bring the climate litigation through the administrative court and ask to cancel the permit with the argument of the climate in Indonesia. And the other one is regulation reform to enhance climate impact disclosure from fossil fuel operation by integrating climate change impact assessment into EIA. Because in just decision and just considerations, just ask the government to make the climate change impact assessment, or ask the government to put the climate risk or the climate assessment in the EIA. So it is one of the policy reform in Indonesia, but we're still waiting the implementations. The another one is the Komari versus the Mayor of Samarinda. Actually, this case is come from it bring by some of the citizens at the Samarinda city, and the plaintiff stated that the Mayor of Samarinda doesn't do superfishing coal mining permits, and it can contribute to the climate change. What is the lesson learned? The first is plaintiff argued that the government failure to supervise coal mining operation violated their rights to a good and healthy environment. So this is the first lawsuits in Indonesia that has contained or has the argument about the human rights, particularly rights to a good and healthy environment. And what is the impact? The impact, actually, we have the two impacts. The first, the use of human rights as the legal basis in the climate case. You know that because the case is a couple years ago, more than 10 years ago. After that, many of the climate litigation in Indonesia, actually it's come from the plaintiff. They are trying to put the human rights principle as one of the argument in their lawsuits. The other one is lawsuits model. It will be the model for the climate lawsuits for the CSO and citizen another litigations. Okay, the notions. Okay, 2 minutes. Okay. Okay. If we're talking about the climate litigation, it's not directly talking about the climate justice. Climate litigation in Indonesia have not yet directly addressed the relationship between the object of the lawsuit and how it's contribute the achievement of the climate justice. There is no lawsuits, there is no just considerations to explain about the climate justice. If we're talking about the climate justice, we're talking about like the distributive justice, recognitions, procedural justice, or social justice like that. But there is no consideration about that, and there is no argument by the plaintiff. So it's something that we need for the further, we need to develop in Indonesia. And challenge from Indonesia experience, yes, limited number of court jurisprudence or interpretation on environmental human rights and absence of strong climate framework to support claims. So how to connect human rights and the climate change is the work home for Indonesia currently. The another one is limitation of judiciary capability, because it's difficult for the judge. Indonesia just only have the legal background, then they don't have another background. Sometimes it's difficult to understand about the scientific informations, even for the EIA. So it's very, very difficult. So it make difficult to hope the judge can produce the good argument for the climate litigations. And what can be improved? Yeah, the first exploration and use of a more in-depth human rights argument, explaining violation of duties more so as the main argument and legal basis in the future environment and climate litigation. Map and develop curated data on the climate change impact, experience in micro or local levels, what it impact for the farmer, for the fishermen, and others. And utilizing established environmental doctrine and principles. This is like the intermediate strategy, because the judge difficult to understand about the scientific informations, and more specific requests or claim aimed at the climate policy or regulation reform. Currently in Indonesia, more than 30 NGOs ask the government and the parliament to develop the climate change act, but it's still discussed. I think to keep track of the environmental case law development in Indonesia, so you can go to ICEL portal. We created landmark environmental decision database at the ilead.icel.org.id, and I stop here. Thank you.
Okay, thank you very much, Reynaldo. Yeah, it's very interesting. Especially as a litigator, it's always very interesting to learn about some of the features of the legislative frameworks in other countries that enable climate litigation to occur. So we heard from Reynaldo about some of the issues around how do we define climate litigation, some of the interesting differences between the government standing and the types of claims the government can make if they're the plaintiff versus NGOs. That was a very interesting feature of Indonesia's system, as well as the Government Administrative Act, some of these enabling conditions that are contributing to the growth of climate change litigation cases in Indonesia. With that, I will hand it over to Shuting for presentation on multi-stakeholder climate governance in China.
Yeah. Thanks for BJ's introduction. And because Climate Earth is an international organization based in Beijing, in China, and so my presentation will be a bit different from those NGOs, local NGOs based in their home countries. I will briefly introduce how Climate Earth works in China and in which ways we contribute to building a multi-stakeholder climate governance system in China. And a brief introduction is Climate Earth, as some of you may know, is a environmental legal non-profit organization based in London. We use the power of the law to change the system, including informing, implementing, and enforcing the law, etc. In China, our approach is a bit different, especially after the issue of international NGO law in China. We didn't support or do or directly fight environmental litigations in China. We use some cooperative approaches, chiefly including research, exchange, capacity building, etc., to work with Chinese governments, judiciary, and NGOs to, support the development of climate legislation, strengthen the role of civil society, improve environmental enforcement, improve environment adjudication, etc. So I know nowadays, also including in this meeting, we talk a lot about what NGOs can do or should do. But from my own experience, and I want to ask what we can do for NGOs. For instance, in China, some survey, very recent survey indicate that the average staff for Chinese NGO is just 3. The average annual income for them is less than 30,000 US dollars. So with this limited financial support and staff, how can they contribute their role to environmental protection and climate change? This is the question I often ask for myself during my career, and also we want to explore what clients can do or what other partners can do. So in 2018, clients, oh, there is a mistake, error. It's about clients and the Chinese Environment Protection Foundation, which is affiliated to Ministry of Ecology and Environment in China, jointly initiated the NGO fund to provide financial support and capacity building to Chinese environment NGOs. Because as an international organization, we don't have that room, or we don't have that experience to directly give fund to Chinese NGOs, because we didn't understand them that much. But we can raise international fund, and the CEPF can raise domestic fund. We make joint efforts to financially and technically support Chinese NGOs. So until now, we have conducted 5 rounds of grant to over 30 Chinese NGOs, and the total grant has reached about $2 million US dollars. I think some of you may understand it's not that easy work in China and also in this field. So we are proud of that. So this is a general overview of how we did this kind of funding. We provide financial and capacity building, and because we understand that a lot of NGO received or are fully occupied with applying for and implementing project-oriented fund, we don't think that's very sustainable for their development, because they should have their core capacity and core mission. In order to support this trend, we use this fund to improve NGOs' institutional capacity, which means they can use that for their staff, for their rental, for their computer, etc. Even more than 90% of fund can be flexible used on this. They can hire legal staff. It's kind of luxury work for local NGOs to hire a lawyer, in-house lawyer, but we did that, we support that. And secondly, we invite a lot of experts, including lawyers, professors, etc., to provide trainings to support their law and policy advocacy capacity. And thirdly, we want to facilitate NGOs' participation in climate governance by collecting them to our other partners, including international partners and Chinese partners. But still, we don't support NGOs' litigations in China, because we know the red line of the law, but we believe their improved capacity can contribute to China's climate governance system in many ways. So when we talk about the next question is how we help the NGOs or how we collect our partners together. About 2 years ago, we initiate a multi-stakeholder climate governance project. We aim to bring together government-affiliated research organizations, environmental law enforcers, and NGO stakeholders, universities, etc., to conduct joint trainings and researchers towards building a multi-stakeholder climate governance system in China. For instance, nowadays, our climate governance project, including these diverse types of partners, including NCSC is China's Climate Change Research Center affiliated to MEE. They are responsible to provide technical support to China's climate change lawmaking, and also climate-related law enforcement agency, also affiliated to MEE. Also 2 NGOs, including Friends of Nature, IPE, which is chiefly responsible for promoting information disclosure in China, and also China's environmental NGO platform, which aims to support Chinese NGOs to go abroad, to go international, and also university. So, for instance, for cooperation with NCSC, our main objective is to provide or to promote climate-related legislation in place at central and local level. as an international organization, we cooperate with them through, joint comparative researchers, workshops, etc. Most importantly, we bring our other, stakeholders or partners, including important, participant NGOs together in this research. So those lawmakers can get access or get fully better understanding of NGO's role, and then include some considerations of public participation, information disclosure, access to justice, etc., into related lawmaking process. So we believe that's very important. And secondly, for the Environment Engineering Assessment Center, which is Environmental Law Enforcement Center affiliated to Ministry of Ecology and Environment, we want to cooperate with them to improve climate-related law enforcement. Our working approach still, takes the form of some comparative study workshops. It's very similar to our, approaches in cooperation with other partners, but most importantly, we still want to bring NGOs, academics, lawmakers to the research, to the cooperations with the law enforcers. So it's another, better exchange platform. And this is our cooperation with university. We provide pro bono, trainings, non-profit trainings to lawyers and other NGOs. This is one event in 2012. And this is our cooperation with Friends of Nature, which is, I think, the one of the earliest environmental NGOs in China, because Friends of Nature has done a lot of environmental litigations, including climate case in China. But as I mentioned before, we didn't support climate litigation, but we, through joint research and other workshops, etc., to work together with Friends of Nature. For instance, in 2012, we have two topics. It's about carbon reduction and pollution control for chemical industry park, and for iron and steel industry. We, our lawyers and Friends of Nature has jointly drafted some legal research reports and to be used for some joint trainings for or workshops for other stakeholders, especially local NGOs, because for instance, as a Beijing-based large-scale NGO, Friends of Nature, sometimes they shoulder the responsibility to build the NGO field across China. So that comes to the question, or to the mission I mentioned at the beginning, that before we ask or we request NGOs to do something, we should ask ourselves what we can do for them. And the Institute of Public Environment Affairs is an organization focused on collecting and analyzing public environment, government and corporate environment information. So we want to promote corporate climate-related information disclosure. And we also taking the approach of working with partners of the whole project through research, trainings, and advocacy. I want to mention one interesting example is Professor Wang is also sits here. Professor Wang's organization CLAPV and IPE has co-identified some core issue, for instance, some law and policy that can promote environmental or climate information disclosure, and they jointly train environmental NGOs, very local ones, to apply for that information. It's like homework or practice work for them, and after being trained by IPE and CLAPV, they really applied and obtained the information they need. On the other hand, they have got trained by the very renowned NGO and law professors through the whole process. So this is the China Association for NGO Cooperation, who wants to support Chinese NGO to participate in international climate governance. So as I mentioned, in the whole climate governance project, we have government-affiliated research organizations, NGOs, etc. We produced a lot of research outputs and law and policy improvements outputs, etc. And because in every year in the UNFCCC COP, NCSC as a national climate change center, they have an official China pavilion. And sometimes, especially in this year, I heard that they will set up a spatial zone for Chinese NGOs. And also, because NCSC is our key partner, and all of the research and all of the other achievements of this project will be presented in the China pavilion of, in COP28. And we believe it's also very important for Chinese NGOs to bring their stories, their challenges, and their success to the international platform. There's some other example, even though it's not climate change, but it's a biodiversity COP, how we contribute to that. It's a very fancy and interesting picture. And last but not least, we also cooperate capacity building development training projects for judges and prosecutors. My other colleague is responsible for that, but as I mentioned, the important is we use the similar approach for comparative study, for exchange, capacity building, etc., to cooperate with SPC and SPP, the judges and prosecutors in China. For instance, we also want to contribute to including the preventive public interest litigation principle into China's, climate-related litigations, etc. And also, we believe all of these projects are interconnected with each other. Sometimes it's not that easy for NGOs or civil society to formally have cooperations with lawmakers, law enforcers, or judges or prosecutors, but through some, platform such as our cooperation, workshops, etc., we can invite every stakeholder together to have informal exchange. We believe these ideas or these seeds can sometimes contribute to real change, for instance, to contribute to China's dual carbon goals in the end. Thank you.
Thank you very much, Xu Ting. I think the presentation brought up a few very salient issues. One is very interesting to hear about the NGO fund and the great work that Client Earth is doing to support NGOs. And I think since we're talking about climate litigation, you bring up another important issue, which is that, for all of the public interest lawyers in the room here, I think we all know the challenges. The litigation itself is often only half the battle. The other half is getting the funding and the support we need to actually do the litigation in the first place. And even though I think you said Client Earth does not fund litigation, did I hear that correctly?
Yes, our lawyers or our other staff in other countries, they have filed some climate litigation directly, for instance, in European countries, and they support some other litigations in some jurisdictions, if that's allowed. But in China, we didn't directly fund climate litigations.
Right. Yeah, it can be a challenge based on the context, the country within which you're conducting the litigation. And also funders are often hesitant because litigation can be long, expensive, unpredictable, so it's often a big challenge. But it's great to hear that there's organizations like Client Earth that are providing other forms of support in terms of training and capacity building, and working together with government prosecutors and judges. I think that's a really important point, that there's a lot of cross pollination that can happen there, exchange of information between NGOs and prosecutors. With that, I will hand the mic over to Renee, I think is next, or Shella? Sorry. Okay, Shella is next.
I can go ahead. Thank you so much for that, BJ. Hello, everyone. My name is Shella Chowdhury, and I am here on behalf of the Asian Environmental Compliance and Enforcement Network. That's ASEN for short. It's a tremendous pleasure to be able to speak with you all today. So the topic of my presentation is on public litigation in Southeast Asia as an emerging pathway for compliance as well as climate justice. So to begin, I would first like to speak a little bit more about ASEN. ASEN was first established in 2005 with the assistance from USAID as well as the Asian Development Bank, with a specific focus on improving compliance with environmental laws in Asia. The Institute for Global Environmental Strategies, which has an office here in Bangkok, has been serving as the Secretariat for ASEN since 2012. There's currently 18 member countries, which are listed on the screen here behind me. And the network serves primarily as a platform for collaboration between senior environmental officials and seeks to provide its members with access to different capacity building resources and just an opportunity to collaborate and harmonize. So with that compliance and enforcement lens in mind, I would like to start by introducing a term which is fairly self-explanatory and probably extremely familiar to many of you, implementation gap. So put simply, implementation gaps occur when a jurisdiction has laws on the books to address an issue, but a lack of compliance and enforcement prevents the issue from actually being solved in a tangible way. So in the last several decades, we've seen many countries around the world work hard to summon the political will to develop legal frameworks for environmental and climate protection. And though, of course, there's a lot more to do in that realm, as we've discussed a lot over the last few days, there is now a growing body of legal tools and legal frameworks on the books in many countries in Asia that can be utilized to support efforts to provide climate justice to different vulnerable communities. So there's many reasons that implementation gaps arise, and likewise many different types of interventions which can be used to address them. However, over the last decade, public litigation has emerged as an especially powerful tool in that toolkit. So when citizens, environmental organizations, or communities pursue litigation against their governments, they have the opportunity to compel agencies and officials to comply with legal obligations. Landmark cases from the last several years, like Urgenda v. Netherlands and Ligari v. Pakistan, have shown the world that public litigation can be used to compel governments in both the global north as well as the global south to take action on climate change. So if you take a look at the chart behind me here, you can see data that's been collected by Columbia University's Sabin Center for Climate Change Law, which shows the steady increase of global climate litigation over the last several years. If public litigation can be used to compel action on climate mitigation and adaptation, it stands to reason that it should be able to also compel action on climate justice as well. So utilizing a mix of national environmental laws, international law, and human rights law, lawyers can create legal strategies meant to protect communities most endangered by climate change. So for example, a few days ago in the United States, a group of children in Montana secured a major climate justice victory by compelling the state government to protect the rights of youths. And now moving forward, state officials in Montana will have to consider the impacts of climate change on future generations when awarding permits to oil and gas development projects. Now, how that case will shake out as it progresses through the legal system is yet to be seen, but it is itself a big win in terms of precedent. So, though that's an American example, as I noted, this is a global trend, and I wanted to just take a moment to look specifically at the data from the Global South here. So if you take a look, you can see that climate litigation, likewise, has had a pretty steady upward trend in the Global South as well. So despite this increasing trend in climate litigation throughout the Global South, Southeast Asian countries have, up to this point, been a little bit slower to uptake public litigation as a compliance and enforcement tool. There's a number of reasons for this relating to the structure of each country's government, the court systems, and environmental frameworks. That said, on paper, Southeast Asia has several jurisdictions that make extremely promising venues for climate justice litigation. So several countries in the region have laws focused on protecting the environment as well as community rights. Indonesia, Thailand, the Philippines, and Vietnam each also have environmental rights enshrined in their constitution. In the last few years, a few countries in the region have begun taking up climate litigation cases more frequently, as we've been hearing throughout this panel. And the numbers in this table reflect data that is available for Southeast Asian countries in the Sabin Center's Climate Change Litigation Database as of this year. So I also want to take a moment looking at these numbers to acknowledge that while the Sabin Center has its own criteria for defining what constitutes a climate case or climate litigation for the purposes of upkeeping its database, it's very relevant to note that there's more climate cases in the region than we can see in this table for sure. This is in part because climate justice litigation, especially in the Global South, can encompass a much wider set of cases than the criteria used by the Sabin Center. So if you can recall the Peel and Osofsky classification chart that Reynaldo referenced, In his presentation, you can imagine the Sabin Center's dataset focuses predominantly on cases at the very bottom of the chart in the center circle, where climate is the central issue. That said, meanwhile, this conference, both this year and last year, attendees have heard about several cases pursued by the Community Resource Center and other organizations that are meant to protect local communities from mining developments and other environmental harms. And while these cases aren't represented in this particular data set, they are certainly climate justice cases and further show that this type of litigation is certainly on the rise in this region. So in addition to the number, there's been several victories in environmental public litigation more widely that kind of signal a growing opportunity for climate and climate justice in the region. Reynaldo already beautifully covered the situation in Indonesia, but just to kind of summarize, the victory of 32 citizens filing a case in the Central Jakarta District Court to compel the government to act on air quality issues in the city really signals an interest in citizen-driven lawsuits in the country and really helps to show that trend of success in an environmental area and hopefully lay the groundwork, as Reynaldo talked about, for climate issues as well. In the Philippines, the Commission on Human Rights issued a landmark investigation on the carbon majors. Their report concluded that 47 of the world's largest investor-owned fossil fuel companies can be held liable for human rights abuses. So this creates a new opportunity for litigation against those corporations, but it may also provide a lot of useful information for litigation against government entities as well. In Thailand, environmental organizations have filed lawsuits in the Central Administrative Court complaining that the National Environmental Board, the Ministry of Natural Resources and Environment, and the Ministry of Industry were in violation of their duty to protect air quality as well. And before a decision was even rendered in that case, the Air Quality Standards Subcommittee proposed revised air quality standards that met the plaintiff's request. And in addition, here in Thailand, there's also an ongoing case, which I'm sure many of you have heard about, filed in the Omkhoi district of Chiang Mai, seeking to protect the local community from the impacts of a coal mining development project there. Now, while that case is still ongoing, the case requests the revocation of an environmental impact assessment on the grounds that it was not created in line with the proper procedure, among other issues. And while that case, like as I said, is still ongoing, the court has recently issued a protective order to prevent the operation of the coal project until the case is fully adjudicated, which hopefully signals a positive outlook for focusing on really thinking about these issues closely and trying to protect communities in the meanwhile as legal developments occur. So cases like these really show that victory on environmental issues in Southeast Asia is possible and hopefully will create helpful precedents for pursuing climate justice action in the region as well. So with these positive trends in mind, I want to call attention to some of the challenges that citizens and environmental organizations currently face in succeeding in these lawsuits. So the first I'd like to talk about is knowledge gaps. Interviews that we've conducted with some lawyers has indicated that judges may lack knowledge of climate change, climate science, and also show a general reticence to acknowledge international climate change laws as well. And additionally, while some communities might show a very high level of knowledge of environmental rights, other communities may really lack access to that information. So vulnerable communities might not have information about their community rights, their environmental rights, or climate justice generally. The second that I would like to call attention to is public participation. So public pressure and media attention can be hugely influential in these cases. As I mentioned in one of the Thailand examples on air quality, changes were made to the air quality standards even before judgment was rendered, which really points to how much public participation can change the way that different governments are leaning on these issues. And so having a growing body of public participation from a much wider population within country, within the region, and also internationally can be hugely helpful. Third is ensuring enforcement. So even when cases are brought and succeed in court, there still needs to be further accountability to ensure that the ordered actions are carried out and really influencing that implementation gap that I mentioned earlier. And also, while it's not on the slide, I did want to just make reference in connection to this morning's plenary to note that the growing occurrence of SLAP lawsuits in the region from corporate developers also creates its own capacity issue for both communities and environmental lawyers, preventing them from taking on more proactive public litigation when they're focusing on defending from these SLAP lawsuits. So to address these challenges, there are a few different interventions, many of which ASEN would be excited to collaborate on with different partners that I think that can be taken. So as usual, capacity and knowledge building can be extremely helpful. This can take the form of creating open access judicial trainings and developing other learning materials, which is something that's come up a lot during this conference. There's great examples of judicial training courses on climate science and international climate law that have been used in the United States as well as Colombia that can show to be a very useful tool. Another is issue linkage. So climate justice has many intersections with tangible local issues in people's everyday lives. Highlighting these connections in public awareness campaigns can really stir that public participation that helps in these cases, and may also encourage people to get involved with citizen lawsuits in different contexts. Additionally, climate justice has so many intersections with human rights, as we've been talking about in this section and the last. And so involving more human rights actors in climate justice litigation can really expand the profile and influence of both genres of issues. And lastly, I'd like to mention monitoring and evaluation. Improving monitoring and evaluation systems to collect data on different environmental indicators related to climate change can support climate litigation by making that data more widely available, and it can also help on the opposite end when there is success and you get a successful court order. Having a set up and dedicated monitoring and evaluation system for these different criteria can really ensure that enforcement is doing as it's necessary. So to conclude, while there are obstacles to its uptake, public litigation can still be a very powerful tool for achieving both compliance and climate justice in the region. And governments should also support these efforts by creating legislation that empowers these lawsuits and makes courts more accessible to these different issues. Trends indicate that more organizations are recognizing the potential of this tool, and we can probably anticipate more action in this area in the coming years. And our research into this is still ongoing. We're still in the process of developing a report on our findings. So if you have experience or insight to share on public litigation here in Southeast Asia, please feel free to reach out to me or one of my colleagues, Chocho. Both of our contact information is up on screen. Thank you so much for your time.
Thank you so much, Shella. I think that was a great presentation to actually show that climate litigation is actually growing in the region, and that is very encouraging to see, despite the many challenges which you've identified and many previous presenters have identified as well. And one quick thing is give a shameless plug to a couple of my colleagues in the room who are the lawyers who are working on the Omkoi case, which Shella mentioned. So if you have any questions about that, you can ask my colleagues in the back. We were kind of proud of that victory when the court issued a restraining order to prevent the construction of the mine while the case is ongoing, which we agree is an encouraging sign, both for that particular case, but also more broadly that courts and judges are starting to recognize the importance of these issues. Last but certainly not least, I'll hand it over to Renee to provide a summary of the UN Environment Programme's report on global report on climate litigation. Renee?
Thank you, and thank you all for still sticking with us to the end. So it's the last presentation. I will try to be quick. So my presentation will be on UNEP's recent report on climate litigation, the status report for 2023, which was launched just a month ago. So UNEP has been preparing these global climate litigation reports since 2017. There was another one in 2020, and then we have our most recent report that was launched in July 2023. This report was researched by the Columbia Law School, by the Sabin Center for Climate Change Law based in the Columbia Law School. And we've used the information that they've collected in their database of climate change litigation to compile the findings of this report. So like what was mentioned in the previous presentations, the definition of climate change was limited to cases that raise material issues or law or fact relating to climate change mitigation, adaptation, or the science of climate change. And we also expanded the scope to cover cases that were brought before a range of administrative, judicial, and other adjudicatory bodies. So not only climate change litigation at the national level, but regional and international tribunals were also included. So this gives you a kind of snapshot of the findings of the 2023 report. So, and the 2023 report covers cases and litigation up to the end of 2022. So if in blue, you'll see what was reported in the 2017 report, then in red, the 2020 report and the 2022 report in yellow. So you'll see that climate litigation has doubled, more than doubled globally since 2017 when we first reported on this. Today, we have counted 2,180 cases in over 65 jurisdictions around the world. You'll see that the number of cases filed in the United States of America has dominated the total number of cases. And that has also significantly increased from 2017 at 654 cases to 1,522 in 2022. But in cases in jurisdictions outside of the United States of America, this has also significantly increased, almost threefold. This sort of gives you a very difficult to see snapshot of the total number of cases, but I think what this illustrates is that firstly, the majority of cases do originate from the United States of America, so around 70% of the cases come from the USA, but we also have a number of cases coming from jurisdictions and adjudicatory bodies from all over the world. In this region, you heard some coming from Indonesia, Thailand. We also have cases noted in China, Nepal, Pakistan, and the Republic of Korea. And you'll see in the next slide that the top 10 jurisdictions include Australia, the UK, Germany, Canada, Brazil, and so on. And within the top 10, we have Indonesia as well. So they have these are top 10 jurisdictions outside the USA and the European Union. So we see that climate litigation has really taken off outside of the global north, as was mentioned by Shella, and is really starting to increase rapidly in the global south. So if you look at a breakdown now per region of the climate litigation cases that have been monitored by the report, we'll see that still Africa and Asia remain the two jurisdictions with the least amount of climate litigation cases. There could be many reasons for that. The Sabin Center, and these are cases that are reported and followed by the Sabin Center database. So that is not to say that there may be cases outside of the database that have not been included, but the Sabin Center has a global network of peer reviewers that aim to identify these cases and add them to their database over time. And many of the reasons could also be linked to some of the challenges that litigants face when seeking access to the courts, as was mentioned in some of the previous presentations. So who is bringing this litigation? The report notes that women's groups, even senior citizens groups, children, indigenous people, and small island developing states are some of the main litigants bringing these cases throughout the world. So that has been a very important and interesting development, that the way in which climate litigation has been empowering vulnerable people all over the world. And I wanted to break down the cases the categories of cases that the litigation report focuses on, and really highlights that most cases have fallen into the following categories. They have been rights-based climate litigation, and I'll go into some of these a little bit more in the next slides. There's been domestic enforcement cases seeking to keep fossil fuels in the ground, and then cases really focused on private entities for their corporate liability and responsibility, also in the context of greenwashing, and then cases against governments for the failure to adapt to the impacts of adaptation. So just to go into the first category on rights-based climate litigation, this category really referred to the actions that assert that insufficient climate change mitigation or adaptation violates the plaintiff's rights. And these included a range of rights, from the right to life, health, food, water, liberty, family life, a healthy environment, a safe climate, but all of them having an impact on climate change. And so these rights have been variously known as human rights or environmental rights, or and human rights obligations related to the environment. So I just wanted to also point out a couple cases that were also very significant. And there was one brought before the United Nations Committee on the Rights of the Child. And in this case, this was a case where it was asserted that the potential harm of the state's acts or omissions regarding their carbon emissions was reasonably foreseeable. So it actually linked the actions of the government to harm that was experienced. And in this case, the court found that the petitioners had pleaded sufficient facts to establish that they personally experienced significant harm. So I think also significant from the point of view of how in an international court, it was found the links between the human rights and the high carbon emissions were found. In this recent case from Australia, which was brought before the UN Human Rights Committee by a group of indigenous people, they claimed that Australia failed to take measures to adequately protect indigenous islanders against adverse impacts of climate change. And this led to a violation of their rights to enjoy their culture and to be free from arbitrary interferences with their private life and family and home. And what was interesting about this case was that it didn't, litigants are using more and more or coming up with more and more innovative ways to link their rights related to the environment and climate change to various human rights, and they're going beyond the right to life and the right to a healthy environment and finding violations of other fundamental human rights to defend to compel obligations by the states. And I wanted to just quickly talk also about three particular developments in international climate rights cases. In these cases, in the first case, brought before the International Criminal Court, this is against the former president of Brazil for his role in crimes against humanity resulting from deforestation and related to activities. So this could potentially be the first time that that deforestation or interferences on the environment or environmental degradation has been linked to a criminal harm. And then you have the last two cases brought before the ICJ and the International Tribunal of the Law of the Sea, which are requesting an advisory opinion from these courts on the roles of and obligations of states with respect to climate change. And these are interesting also because it would be the first time that these courts have given advisory opinions on the obligations of states on climate change related to international law. It would also be, it's also interesting because the proponents of these actions have been small island developing states. So again, litigants who have more or less been marginalized from the climate change discussions, but are now empowered and are driving actions on climate change. So in another category of cases of climate change litigation brought before national courts, we're also seeing that litigants are using the domestic fora to argue that climate change obligations are arising from a national constitutional fundamental rights. So we have the newborn Germany against Germany case, where it was found that the Climate Protection Act was incompatible with constitutional rights to life and health. And there was also a case in Brazil where plaintiffs are requesting that the national climate change policy be updated to align with Brazil's global greenhouse gas emissions, to be in line with a 1.5 degrees Celsius global warming scenario. So we're seeing also a set of cases where litigants are using existing national laws to enforce rights and to, again, drive action on climate change. In terms of domestic enforcement cases as well, litigants are also seeking to compel governments to implement or to challenge them on how they've implemented their national laws. And we've seen in France that the court held that the state's inaction on climate change and failure to meet its carbon budget goals caused climate-related ecological damages. And again, other cases compelling the government to adhere to its mitigation commitments. In another category of cases where litigants are seeking to challenge the government action to keep fossil fuel, these cases are centered around government action to extract fossil fuels. And so they seek to compel governments to adhere to the Paris Agreement and to adhere to their net zero commitments. And in the category of cases related to corporate liability and responsibility, now litigants, there's a trend that we've been seeing in the last few years where now litigants are seeking to hold private companies accountable for their fossil fuel or their greenhouse gas emissions. And the case against Shell in the Netherlands was the first case in which a private company was held by a court to have obligations under the Paris Agreement, which, as you know, normally creates obligations on states.
Sorry, Renee, I ask you to
Yeah.
wrap it up a little bit.
And
We
the,
only have
on
Thanks.
the last related cases against corporate or private entities, there are cases increasingly brought against private entities that are accused of greenwashing, so making false statements on climate change, and these cases usually rely on advertising or industry standards on advertising. But what we see is that there's an increasing target of private companies and their liability on climate change, and they're being asked by courts to take action. The litigation report also goes into updates on past predictions and future directions, as you can see here. I won't go into them, but just really to say that more and more cases are being brought by vulnerable groups, and that is expected to increase as well. So the key takeaways from the litigation report are that many cases are challenging the adequacy of climate action at the national level, basing them on human rights. And that in the case that I mentioned against Australia, brought by Indigenous people, one takeaway from that case that was mentioned in the case was that international courts and tribunals have created a pathway for individuals to assert claims when national systems fall short. The litigation report does mention and does highlight that governments have been the target of the majority of these climate actions, but it shows that, as I mentioned before, the private sector's accountability is growing as well, and this is an area that is expected to expand. Thank you.
All right, thank you so much, Renee. That was very interesting to see, as we said in the beginning, this discussion would focus on innovative legal mechanisms and initiatives to address the climate change, and I think your presentation really summarized a lot of those innovative measures that people are using, including mechanisms before the UN Committee on the Rights of the Child, the UN Human Rights Committee, as well as the international tribunals, the International Criminal Court, and the Court of Justice. I was honestly kind of surprised to see that the United States had so many climate change cases. But we also have a political party that kind of doesn't believe in climate change, so that presents a challenge of its own. But with that, I will open it up if anyone has any questions for our panelists. Yes, to our delegate from Nepal.
Namaste, everyone. My question is to Ting Ju about the NGO Capacity Building Fund. As how the money is collected for the fund or major source of income, and how the fund is mobilized, the mobilization mechanism, how the NGO are selected criteria, and a monitoring mechanism over their activities of NGOs. Thank you.
Yeah, thanks for your question. Actually, that's a question we are frequently asked by our headquarter funders, Chinese government agencies, etc. And yes, and the financial support is very key for NGOs development. And secondly, as I said in the presentation, we cooperate with China's Environment Protection Foundation, which is a government-supervised environment foundation, which is only one government-supervised environment foundation dedicated to providing financial support to NGOs in China. So they have the legal standing, they have the experience to do so in the past, decades. They have a very complete or very large database of Chinese environmental NGOs. They even know the histories, the challenges, some violations, probably, of Chinese NGOs, etc. So we trust them, we cooperate with them, and during the implementation of the fund, we set up an evaluation committee, including client's representative, CEPF representative, and consultants from government agencies, university representative, etc. And together we issue open call for proposal to state very clear condition for application. And secondly, after receiving that, we do initial due diligence of that. And then the evaluation committee will give scores to these NGOs based on the preset criterion by the committee. And thirdly, the shortlisted NGOs will receive interviews or evaluations, in-person interview and evaluations from the committee. Fourthly, the NGOs will be finally selected, and we will publicly issue the names of these NGOs to see who have any objections, etc. And fifthly, lastly, but I think the most importantly, CEPF and their supervisory units, Ministry of Ecology and Environment, have the final veto rights. Even some NGOs has come into the final list. They can veto that based on some can be disclosed or can't be disclosed reasons. And we respect that veto rights, and I think that veto rights can ensure the compliance of the foundation, the safety of the foundation across China. And the monitoring and the evaluation of these NGOs' activities are conducted by CEPF. They have the legal standing to do so. They have fully access to all of the financial and project information of these NGOs. But we won't and we can't have access to all of these NGOs' information, and we don't need that according to Chinese laws and regulations. But we have cooperations. CEPF is our partners, so we have very strict monitoring and evaluation procedures for CEPF. They should claim and they should provide financial and narrative reports to us by saying how this whole project is implemented and how the financial rules are, compliant, etc. So our MEL procedure will go to and stop at CEPF level. So it's I think it's a well-designed and very well effective implementations for this foundation to ensure its full compliance, safety, effectiveness, and sustainability in the Chinese context. Yeah, thank you.
Thank you for your presentation. It's very interesting today and wonderful. And I have some question for Mr. Reynondo. Sorry if I pronunciation your name wrong. So Indonesia have a climate litigation from the government side to that sue the company, right? And are there any impact of suing like this case to the indigenous people or not? Because of in Thailand, we have similar case like this, that forest department used to sue the villager and call the compensation from cutting the tree, but somehow this litigation can turn the weapon to the community side also. Instead, use of this litigation to enforce the big company who can source the climate change.
Yeah, thank you for your questions. Actually, in Indonesia, for the government legal standing is never puts the community's rights or the indigenous community in their lawsuits. There is no argument about that. Why? Because it's still debate in Indonesia about the status of the indigenous people. In our law and Indonesian's policy, government policy, indigenous people must enacted by the local regulations, local law, or by the major or head of district decisions. So if they didn't get the status, so in the legal formal by the side of the government, so they are not acknowledged that as the indigenous people. I think it's some of the challenges in Indonesia, because the indigenous people is broader from the legal formal or the legal status like that. So that's the reasons, because sometimes it's difficult to define who is the indigenous people. So the government sometimes need to check are they registered at the local regulation as the indigenous people or not, like that. So and of course for the human rights is not put in their lawsuits. Thank you.
If I can follow up on that question real quick, because Dream, correct me if you're wrong, I think your question is basically who are the defendants in the cases in Indonesia?
Oh, defendants.
Is that? Yeah, because I think in Thailand there have been some instances where the government has used a similar provision to file cases against villagers, like local community members, for cutting down trees, basically. Yeah.
The defendants only the company. Only the company. Yeah.
Thank you. My question is also related with the question from Thailand. It's on the government as plaintiff in environmental cases. It's opposite in the Philippines, because in the Philippines mostly it's the government who's on the receiving end, or as defendant or respondent. So my question is, in filing these cases, do you adhere to the exhaustion of administrative remedies before filing these cases? And the second point is, how do you value the damage in seeking for compensation?
Yeah. Okay. Yeah, it's somehow hurdles about the economic valuations in Indonesia. It's still a debate, and the government still use the ministerial regulations on the environmental economic valuations. So they just follow the formula. One of the formula is valuation of the carbon release, like that. But if you ask to me, actually, many scholars, particularly legal scholars in Indonesia, see the ministry regulation on the economic environmental valuation has many gaps. And because if we talking about the formula or about the violation, it's difficult to make in the regulations, because knowledge or the science is broader than a law or than a regulation. So that's make our Indonesian government just follow the methodology that stated in the minister regulation, so they don't accept another methodology. So it's the issue about the economic valuation. But why many of the scholars or legal institutions like ISEN, UNEP have been put the government legal standing or government lawsuit in Indonesia as the climate litigation, because one of the valuation is about how to evaluate the carbon release, and it's will equal with the sum of the money, and they will request to the company to pay the money and for the restorations like that. And what is your first question, Pardon?
It's with regard to the administrative exhaustion. That before going to courts, we have to resolve first administratively within the powers of the agency.
And I think for the government legal standing, do you mean? No, so the government can directly bring the lawsuit to the court like that. Thank you.
Okay, I think we'll have time for one final question, and then I'll have to cut it off. Otherwise, everybody will get mad at me. So.
Okay. Thank you so much for a beautiful presentation, everybody. This might be a very preliminary question, but it's very important because the concept of climate litigation still in many parts of the world is a very new concept. So considering the fact that Stella and Rene both have used the Savin Center's interpretation of the word climate litigation, if it's possible and if it's not too much to ask, if we could receive a small summary, what does the word climate litigation constitute as per the Savin Center? And secondly, I still remember when usually the courts who does not have the definition of the word climate litigation, they tend to refer to Savin Center's interpretation of the word. But the problem is the legal authority of the Savin Center might not be binding to different courts across the globe. And because the judges don't have legally binding authority, it is very difficult to validate the elements that the Savin Center provides. So I don't know whether this question would be relevant or not. Is there any place or any countries which have a different approach of looking at climate litigation when it comes to different elements compared to that of Savin Center or not? That would be my two questions. Thank you very much.
Yeah, please.
Thank you. When you research the case on the mitigation, what is the factors determine the occurrence of the climate change lawsuit? Because maybe it depends on the cause and consequence, and the relationship between cause and consequence is very difficult to prove. So in Vietnam, it's very difficult to prove that. We don't have any case on the climate change and also the environmental protection. So, or the another factor that the regulation system on climate change is not enough, or it have many gaps, or the effective of the judgment system, or we don't have any lawyer on this problem, or the people are supported to follow it. They don't have any supported. So if you have research on the mitigation, I think you need to have address the question I propose to. We need to propose the solution to help the people protect their right on the climate change and on the environmental protection. So it's better. Thank you. What is the factor?
Yeah, thank you for that question, Ashish. So, as I was saying a little bit in my presentation, so the Sabin Center's definition of climate litigation is one that they've kind of pulled more from the academic literature rather than any particular country's legal definition of what climate litigation entails. I think the Peel and Olofsky model that Ronaldo brought up was a really good way to think about the different things that can be considered climate litigation, and it can be different context to context. So in the Sabin Center definition, it tries to focus specifically where there's a question of factor law, where that involves climate change, which is what Renee's presentation mentioned in the definitional section, versus something like climate justice, I think, takes a much broader definition of climate change. So for example, with the Koi case, you have a mining development that is a fossil fuel development that endangers community rights, community safety, community health, livelihoods. And that should also be considered a climate justice case in my larger definition. So I think that each country doesn't necessarily need to worry about adopting a strict definition of climate litigation. It's more for classification for the onlooker and for the lawyer in thinking about the case. Now, I think that that can have definite legal consequences, approaching something as a climate litigation versus a human rights litigation, or where those intersections are, but it can be relatively flexible.
And thanks also for your question. I think just to build on what Shella said, the definition of climate litigation has just been really important to developing the report and to defining the scope of the report. So, we've seen that there's over 2,000 cases that we've looked at and included in the report, and there must be some way to delimit that scope. And so that it's for that reason we use the definition of climate litigation, so that there's some kind of criteria developed that we can analyze the cases and compare them. So it's really just important in that sense. It's really, and Sabin Center has developed a database of climate litigation, and so we've used them we've used their database and their knowledge and research to develop this report. So really, it's just important from that sense. But of course, anyone can have their definition of climate litigation that is different. And then the representative of Vietnam, I just really got the first part of your question on climate attribution, and it's not an area. I mean, you're totally right. This is really the central. The cases will turn on whether you can attribute harm caused by climate change impacts to the claims of the plaintiff. So, and how have plaintiffs been doing that? That is not so much covered in the climate litigation report, except to say that this has been a central part of the cases that plaintiffs have brought, and that it's an area that is likely to get more attention. I think more and more courts will turn to parties and require them to provide evidence that the harms that they are claiming have been caused by the defendants, which are the governments or the private companies. But in many cases, we've seen that even with the evidence provided, and plaintiffs have been doing that, have been bringing information about emissions, for example, to show that the harm can be attributed to the emitters. And in many cases, they have been successful. So a lot too turns on the interpretation of the court and how they find that this evidence can be used in favor of the plaintiff. So you're totally right, and that this is an important area, and that's a great question too. Like how have plaintiffs been finding this link between the defendant and the harm caused? And I think that's, courts take different liberties, and courts around the world have been doing that in different ways. Some have been more successful than others, but I think each case will be very different.
Yeah, just for the Indonesian context, at least for the Indonesians, I want to respond the representative from Nepal. at least for the some of Indonesian scholars and Indonesian lawyers, we have agreed that definition of the climate litigation and the scope is only at the civil court and administrative court. So there is no at the criminal court. So why? Because it's very dangerous if we put the CO2 as the criminal provisions. So it's not only, you know that motorcycles, we produce CO2, so it will be very dangerous for the people. That's the first. The second one, I don't know is related to your question or no, but I think it's important. The climate litigation is need the enabling conditions. What the enabling condition? The enabling condition, what we are discussed at the previous sessions, human rights, anti-SLAPP, and another. So it's the important things before we further discuss about the climate litigations. Thank you.
Thank you very much. And I think with that, I have only allowed the panel to go 10 minutes over time, so I don't think that's too bad. Thank you for the great questions. And before we conclude, I just wanted to remind everyone that we will convene again at 9 a.m. tomorrow for a full day of discussion around the development of an ASEAN Regional Environmental Rights Agreement under the ASEAN Intergovernmental Commission on Human Rights. So we very much look forward to getting your ideas and inputs on that process. If we can give one final round of applause for our great panelists. Thank you again, and class is dismissed for today.
Thank you.